Level 1. No money for bail. You are arrested on a Tuesday. The charge is a felony. The bail is set at $7,500. You do not have $7,500. You do not have $750 for a bail bondsman's 10% fee. You have a job, a phone, and a family that cannot cover it either. So you wait. Not because you've been convicted of anything, not because a judge decided you were dangerous, because you are poor, and the system interprets poverty as a risk it needs to manage by keeping you in a cell. On any given day in the United States, roughly 500,000 people are sitting in pretrial detention. Most of them are there for the same reason you are. Not guilt, not danger. Inability to pay a number a computer generated based on the charge. Your public defender is assigned 3 days later. They are not bad at their job. They are carrying 200 cases. The time they have for yours, to read the file, to call you, to think, is not enough. It was never designed to be enough. The prosecutor offers a deal in week 6, plead guilty to a reduced charge, time served plus probation. You've already been in for 6 weeks. You have a job that may or may not still exist. You have children. The trial, if you demand one, is 8 months away. You take the deal. This is not a failure of the system. This is the system working exactly as it does for people at this level. The outcome was produced by a sequence of mechanisms, each technically legal, each individually defensible, and collectively calibrated to process people who cannot afford anything else. You now have a conviction on your record. That record will follow you into every job application, every background check, every housing form for years. The original charge is gone. The consequences are permanent. Level 2. Enough for a private attorney. Bail is the same number, but this time you can cover the bondsman's fee, or a relative can. You go home that night. You sleep in your own bed. You are not making decisions from inside a detention facility. This changes everything about what happens next. You hire a private attorney, not a top firm. A solo practitioner who charges $200 an hour and has time to actually read your file. They call you back. They explain things. They have handled cases like yours before, and they tell you specifically what the likely outcomes are. The same prosecutor who offered a deal in week 6 gets a different kind of response from your attorney than they got from the overloaded public defender. There is negotiation. There is an argument about the strength of the evidence. There is a motion that takes 3 weeks to work through but reduces the charge before a deal is ever discussed. You pay $12,000 before this is resolved. The financial damage is real, but the legal outcome is materially better than what happens at level 1 for the same underlying facts. The law did not change. The evidence did not change. What changed is what you could afford to put between yourself and the system. Level 3. Comfortable income and savings. You can afford a specialist, not a generalist who handles whatever walks through the door. A criminal defense attorney who has spent 10 years on cases exactly like yours. Who knows which judges in your county respond to which arguments? Who has cross-examined the forensic expert the prosecution uses? Who knows specifically that a particular piece of evidence in your case was collected in a way that creates a suppression argument worth filing? Specialization is not a luxury at this level. It is a legal strategy that produces different outcomes because the law is complex enough that knowing which parts of it apply to your situation is worth more than anything else money can buy inside a courtroom. The case gets dismissed, not because you are innocent necessarily, though you may be. Because the legal mechanism that existed to get it dismissed was found by someone with the time and expertise to look for it. At this level, the law also becomes a tool you can use offensively. Someone defrauds you. A contractor takes your money and disappears. An employer violates your contract. At levels 1 and 2, the cost of civil litigation often exceeds whatever you'd recover. Here, you can actually sue. You can be taken seriously. The law works in both directions now, not just as a threat you respond to, but as a mechanism you can deploy. Level 4, wealthy. The goal at this level is no longer to win the case. The goal is to make the case expensive enough that it never becomes a case. You have a relationship with a law firm, not for emergencies. On retainer, someone who knows your business, your contracts, your exposure. When a problem develops, a regulatory inquiry, a disgruntled employee, a business dispute that is heading somewhere bad, it is addressed at the earliest possible stage, before charges, before filings, before anything is public. NDAs are drafted. Settlements are reached quietly. Cooperation agreements with regulators end investigations before they produce indictments. This infrastructure exists entirely upstream of the courtroom, and accessing it requires not just money for a single case, but an ongoing financial relationship with people whose job is to keep you out of the system entirely. When cases do proceed, the resources deployed are different in kind. not just scale. Expert witnesses who have testified in hundreds of trials, forensic accountants who can reconstruct financial records in a way that creates reasonable doubt where the prosecution saw clarity, investigators who locate witnesses the other side didn't know existed. The cost of this machinery is measured in hundreds of thousands of dollars. It exists to do one thing: make conviction difficult. The conviction rate for white-collar defendants with full legal resources is significantly lower than for defendants without them, not because white-collar crime is harder to prove, because it is made harder to prove. Level 5. Very high net worth. Above a certain level, legal problems do not reach the criminal system at all. They are resolved before that, in spaces most people don't know exist. The regulatory agencies that would investigate you have limited staff and enormous caseloads. A law firm that has former regulators as partners knows how those agencies work internally, which cases they pursue, which they let go, and how cooperation early in an inquiry changes the outcome. The investigation that might have become a prosecution is resolved with a fine and a consent decree. The consent decree requires no admission of wrongdoing. It does not follow you. The civil exposure that would have destroyed someone at level 2 is absorbed through structures built years in advance. Trusts, holding companies, asset arrangements that limit what can be reached in a judgment. This is legal. It is standard practice at this level. It requires years of planning and attorneys who specialize in nothing else. The legal system does not fail people at this level. It does not threaten them in any serious way. It is a set of rules they operate around, with professional guidance, in the same way a business operates around tax code. Compliance is managed, exposure is minimized, risk is priced in and planned for. Level 6. Institutional wealth. At the highest level of wealth, the relationship with the legal system is not about navigating existing law. It is about shaping what the law says. Lobbying is legal. Campaign contributions are legal. Funding the think tanks that produce the policy frameworks that agencies use to write regulations is legal. These are the mechanisms through which the rules that everyone else lives under are written in the first place. The sentencing guidelines that produce the outcomes at level 1 were written by people. The bail structures that keep 500,000 people in pretrial detention were designed by people. The regulatory frameworks that allow the consent decree to substitute for prosecution were built by people. And the people with the most consistent access to those processes are the people with the most money to spend on them. This is not a secret. It is public information that sits outside the frame most people use when they think about legal inequality. The conversation usually starts at the courtroom. The courtroom is already late in the process. What you are looking at across these 6 levels is not a justice system that sometimes produces unfair outcomes. It is a system whose outcomes are structurally predictable based on one variable. The same variable that determines your experience with banking, healthcare, housing, and every other institution that claims to treat everyone equally. The law is the same text for everyone. What you can do with it depends entirely on what you can pay for. And the distance between level 1 and level 6 is not a matter of better or worse outcomes within the same system. It is a different institution operating under the same name.